Well, good morning, everyone. Initially, Darcy and I were going to speak to you right before lunch about the changes to the accident benefits schedule that are coming next year, and also some changes to the tort system that have already arrived. And in some ways, I think it's good that we're doing this out of order, because I wouldn't want to put you off your lunch with reviewing all these very punitive changes that unfortunately are coming down the pipe. But I want to echo what John said, that this is the 6th or 7th change to the accident benefits world since 1990, maybe even more. And every time people say that the sky is falling, and every time people like the people in this room and other creative lawyers and people that work in this industry have found a way to ensure that the people that we serve, the most seriously injured people, in Ontario get the services that they need, and I'm confident that we'll be able to do that in this new world. In terms of some takeaways, I would like you to take a look at the paper and the appendices to the paper, which is in your materials. It's at tab 3. There's a lot of detail there. The appendices in particular should be helpful. There are a copy of what the amended statutory accident benefits schedule will look like. That's at Appendix B. There is a chart about the changes to catastrophic, and there's also the regulation that enacts these changes. I want to thank Lara Fitzgerald-Husek, who's an associate lawyer at Oatley Vigmond, who's here today, who helped us write the paper. Without further ado, I guess we'll go to the next slide. I don't have a clicker up here. So in terms of the changes, as I said, the tort changes are already here, and we're going to detail those for you, just in a broad overview, because I know that most of you aren't particularly invested in the way the tort system works. And then the accident benefits changes are coming June 1st, 2016, so it's going to be an almost complete overhaul of what we know today in terms of the accident benefits schedule. There are further changes that will likely come down the pipe in terms of dispute resolution, buckle up, because we're not done yet, but we'll review what's already been out there, and we'll hopefully help you come up with some strategies and ideas for coping with this new world we're going into. So we've broken the talk up into 8 sections. So the first is just a review of the reduced accident benefits, and Darcy's going to speak on that, and I will chime in. Darcy's also going to talk a little bit about the narrowed catastrophic impairment definition. However, we're going to leave that for the panel later to really sink their teeth into, because we've got some physicians and very experienced counsel who are going to talk about the specifics of the new test for catastrophic. Darcy will also talk about the increased tort deductible, and then I will handle the remainder of the slides, but Darcy will also be chiming in as necessary. So I'll turn it over now to Darcy to talk about the reduced accident benefits as of next June.
Thanks. So these changes aren't good. They're not good for our clients, the patients at the hospitals, the people we hope to help. They're not good. There's no way around that. But we're not going to focus on that part of it. We're going to try to deal with solutions and how to deal with the impacts, the fallout from the changes that are coming as of June 1st. So let's just go over them. We'll talk about some of the impacts. We'll talk about some solutions, and I'll try to engage Ryan in the discussion, and we can open the floor up for questions probably at the end if we have time. So first, the reduced accident benefits. The new math. Right now, on a CAT file, it's 1 + 1 = 2, $1 million med rehab plus $1 million of attendant care equals $2 million. The new math is 1 + 1 = 1. So on catastrophic cases, as of June 1st, 2016, so for accidents on or after that date, not on the current cases, just to be clear, nothing affects what's happening now until then, or cases that predate that. But from that point forward, for catastrophic cases, there will be a total of $1 million available. Okay, so no longer 1 + 1 = 2, 1 + 1 will equal 1. And I'll talk about that more in a second. On the non-catastrophic side, instead of 50 + 36 = 86, it's now 65, capped total of 65, and we'll talk more about that momentarily. And then the other substantive change in terms of the amounts available is the non-earner benefit. Now, many of you may not understand what a non-earner benefit is, but it's a weekly benefit in lieu of, instead of, an income replacement benefit paid to students, retirees to some extent, stay-at-home parents in some circumstances where they're not eligible for caregiver, like non-catastrophic cases, unemployed, and it's payable at a rate of $185 per week, and it can go up to $320 a week if there are students. And now it has been available until age 65 and even thereafter at a reduced rate. And for a student, for example, it would typically be present valued at about $400,000, $500,000, the non-earner benefits for life. That's out the window, and it's going to be restricted to 2 years. So it's $18,000 or so available in that benefit. And these people are not eligible for the income replacement benefits. That's how they typically get to the non-earner benefits. So that's out the window. It negatively affects students, stay-at-home parents to some extent, and the unemployed. Let's just deal with the CAT impacts briefly, and then we'll talk about the non-catastrophic issues. So with this new math, the 1 + 1 = 1, it changes the way we work. It means that we got to be a little more careful on how we spend and prioritize. It means that we need extremely sophisticated, experienced teams. Okay, so all of the people in the room who have done a lot of these cases, working and coming up with creative solutions and spending the money diligently, maybe renting instead of purchasing. Okay, because in a serious catastrophic case, we're spending $300,000, $400,000, $500,000 quickly on a new house, on a suitable house, on a vehicle, on treatment, on care. There's just not going to be the same $2 million available. We're going to have to start chiseling it down to the most basic, the most necessary items. So we need a team that's sophisticated and experienced, working together, collaborating, come up with efficient, cost-effective solutions, and prioritizing use. It also means that the tort cases become bigger, because what you can't get on the benefit side, you claim on the tort side. So if the new math, there's only 1 million, okay, our tort cases, our lawsuits against at-fault drivers, the magnitude of those cases increase. Now we often run into limits problems, meaning that the at-fault drivers don't have enough insurance, so it's not necessarily a great solution. And of course, a lot of our clients are partially or largely responsible for accidents, which prevents or precludes or reduces their tort rights. But there's a solution there in the sense that we can expedite, speed up lawsuits, get cases going quicker, so that we have the potential to access another pot of money much sooner. But generally speaking, this change on the catastrophic issue is not good for seriously injured people, and we're going to have to be creative and come up with solutions. Dealing more with the non-CAT changes and the new $65,000 maximum. So I've called it Freedom 65, because while the 50 plus 36, which would normally be 86, is now reduced to 65, the good part of it is that the 65 is not in these two different buckets. It's spend it as you wish. Put it all in med rehab if you want. So that's a good thing. Right now it's 50 only in med rehab. Now we have 65. And because of this wacky incurred definition, we often have had trouble accessing the attendant care. So this way we can kind of maybe give up that case from the accident benefit insurer and work on exhausting and using up the med rehab, which is needed, and focus the attendant care claim on the tort case where we're not subject to this incurred definition, and we can advance claims by family members at market rates without having to deal with proof of economic loss issues. So that's good. The $3,000 per month cap still applies for attendant care if somebody does have extensive needs. But instead of having it limited to 2 years, it's now open for 5 years. And in fact, the whole non-CAT window has been changed. It used to be 10 years, and now it's going to be 5 years, or until age 28 if you're a minor at the time of the accident. So it used to be 10 years to access the med rehab, now it's 5. It's a small change. It will have some impacts, but it's not too bad because in the serious cases, we're usually exhausting that long before 10 years anyway. So in terms of the impacts, the attendant care, move it onto the tort side and tap into the med rehab as best as possible and advance the attendant care and tort along with the housekeeping claims. Ryan, do you have anything you want to add on that point or on the catastrophic point?
Well, I just agree that there are some positives to take away, and one thing that we can do, as Darcy mentioned, is to have a Form 1 that establishes a high attendant care rate, but assuming that there's tort and the family members are prepared to do the attendant care, but they don't suffer any economic losses, there's still $1 million then that can be put towards the medical and rehabilitation side. And as long as we've established that there's a need and that someone's providing the service, on tort, we don't need to prove incurred expense. That's solely an accident benefits issue. So we can try to work it that way if there is a decent tort claim with good limits and the family members are available to provide attendant care. Another thought is we may need to have creative ways to case manage files and to have less case conferences. There are case conferences via Skype or telephone, things where right now we're paying a lot of providers to come together and meet on a quarterly basis or a biannual basis. Perhaps that's a cost that we're going to have to restrict or try to be creative about, because we have to be balancing a fine line of using this money judiciously and using it quickly enough so that the insurer recognizes that it's a serious case and that they will want to resolve it at one point, but at the same time not being at all frivolous with it, because we're dealing with 50% of the money, as Darcy mentioned. So I think there's a lot of opportunity here, but it's going to take the people in this room and council who know what they're doing to work together to try to make sure that this new system works as well as possible for these catastrophically injured people.
So moving on to another new accident benefit rule. This is about the other goods and services category, and if you want to turn it up, you could look at page 15 of the amended SABs, which is the B tab of your materials. So it should be tab 3B, and that's the best pocket takeaway. It's the amended SABs. It's available online too, but it shows the current SABs, and in the darker gray shows the changes as of June 1st. So on page 15 there, the very top is the first one, and then near the very bottom is the second one. And you don't necessarily have to pull it up, but the point is, there used to be this catch-all category for med rehab saying any good that's required can be claimed. Makes sense? Reasonably required makes sense. That's gone. And if you want to take a pen and cross out this new provision, that may be the smartest thing to do, because the new provision says other goods and services of a medical nature the insurer agrees are essential. Okay. It's page 15 of the amended SABs at tab B. Yes. So, okay. This means that the insurer can do nice things when they want to. Good. Okay. It permits them to go off book. Great. We like that. Nothing wrong with that. But if we see treatment and assessment plans that refer to this clause, please don't. There are a lot of other categories there that's the solution. Try to fit it into another category. So, for example, if you're recommending the use of an iPad, call it a communication aid under section I. That's enumerated. It doesn't have to be essential. The insurer doesn't have to agree it's essential. So fit recommendations in an enumerated category, and please never refer to this provision, because we will not ever win on disputing this issue, because it's what they think. If they agree it's essential, sure, we can fight them on the most egregious cases, but we'd prefer if you direct and reference the other sections, and they're expansive sections. They have a lot of wiggle room.
Okay, so just to be clear, it's still reasonable and necessary for all the enumerated sections, so it's just a matter of being creative and finding a way to fit it into those sections. But I agree with Darcy that I can't think of a way that I can litigate the issue. If the insurer says, I don't think this is essential, that's basically the test. So it would only be if they were being malicious and punitive to the point of trying to harm their insured or something, that perhaps we have some ability to win on that issue. So it'll just be a matter of making sure you check the correct box, and that people talk to the council before submitting treatment plans.
So we're not going to get into the CAT issue, because the last panel, a very impressive panel, is going to be dealing with this in detail. But in a 2-minute overview, the new CAT definition is an extremely narrow definition of catastrophic. It eliminates the GCS test, which is the primary, probably the vast majority of the cases we're involved with on behalf of catastrophically impaired persons. get in the door, become catastrophic on the basis of the GCS. It's immediate, it's obvious, we know when we show up in the hospital or soon thereafter that it's there. We can manage the case on that basis, so that's out the window. Again, it only applies to accidents that occur after June 1st, 2016, so it doesn't affect anything before then. Now, we've had 20 years with the same definition, and we finally have a good understanding of how it's interpreted. We have case law in point. We all kind of get it. Now, there's still a lot of debates, but we get it to a large extent, and now we're back reinventing the wheel, new tests, new conflict, new uncertainty. So the impact are delays, and you'll hear from the panel about when these tests can be accessed, but the problem is we're not going to know when we show up and when you're called in to help. You're not usually going to know if the person's catastrophic or will be catastrophic, and frankly, we're probably not going to be in a great position to give you our best guess of whether they are likely to be catastrophic. Over time, we'll get better at it, but in this new world, there's a lot of uncertainty. And it changes our ability to say this person's cat, go in there, do this, that, and the other. So again, you need a sophisticated, experienced team to work efficiently, to understand that possibility and the fact that we're all going to be monitoring advancement, health, to see where on the spectrum of likely catastrophic the case falls. Right.
Absolutely, it's very unfortunate. Darcy and I were both sort of picturing ourselves in a hospital setting, talking to a family with a loved one, and telling them, I have no idea whether your loved one is going to be entitled to $65,000 or $1 million in treatment, and we may not know for a year after the injury, which is a real challenge. And so it's something that we're all going to have to be creative about, because discharge planning is so important, and we need to make sure that it's done properly. But at the same time, if we spend $35,000 making the home safe for the person to be discharged, it's going to be a major problem for someone if they are not eventually being had. So again, it will be something that we'll all learn together about how best to navigate this new system.
But for the people that are here that work within the hospital setting, this is a big change because we no longer will know with certainty that the person is going to be catastrophic, and it means we're going to want the person to stay there longer. We know that's not an option. When it comes to equipment needs, we're going to want to cut some corners. It's going to really affect discharge planning. We're going to have to be more involved, more efficient, more frugal. Moving on to the last point I'm going to speak about before I pass the podium over to Ryan is the increased tort deductible. Now, this isn't a big issue. It's something you should know about. It is a big issue for our side of the equation, but for people helping accident victims, it's in the therapeutic way. It's not necessarily front and center. But currently, there's this $100,000 vanishing deductible, meaning if you have pain and suffering claims that exceed $100,000, you don't pay this statutory deductible. So the same way if you have a fire in your house, you have to pay the insurance company $500 or $1,000 to fix your house or fix your car. A statutory deductible prevents minor claims by saying if your pain and suffering claim's worth $100,000 or less, you don't get the first $30,000. So they've inflated it. They've increased it for inflation to come current since 2003 and effective as of August, so last month, we have a new vanishing deductible limit of $121,799. So you got to, for new accidents, it has to exceed that in order to not have to pay the statutory deductible. If you're below that, you pay a higher deductible of now $36,450 as opposed to $30,000. And for family law act claims, so spouses, children, parents, the increased deductible is $18,000 from $15,000, $18,270. So it's up 20% or 22% because of inflation. Now, anytime there's a change that has a negative impact on accident victims, the insurers say, well, that applies to everything. That applies to cases that are 10 years old, cases yesterday, and the rest of it. So there are battles that Ryan's going to talk about when he talks about some of the other points about whether these changes apply to cases that predate August 1st. We think it's extremely clear they do not affect cases that predate August 1st, but there is a debate, and the insurers will want that pushed to court, no doubt. Ryan.
Well, in terms of the fight on the prospective versus retrospective, there's 3 or 4 items that, unfortunately, the legislature, in its wisdom, decided not to put anything in the law about whether it applies to only new cases or to old cases. And unfortunately, the law is not clear on that. If it's substantive change or procedural change, it goes one way or the other. So it's something that we're working on, and I'll get into that when I talk about the incurred expense. I'll just pop back up there. So this next slide is about a change that has not been introduced into law yet. In Bill 15, which you might recall was passed in November of 2014, part of that law said that they were going to take dispute resolution for accident benefits claims away from the court system and away from the Financial Services Commission that you all may be familiar with, and move it over to an existing tribunal called the License and Appeals Tribunal, which right now deals with things like liquor license disputes and driver's license disputes. And they are going to somehow hire a bunch of part-time contract adjudicators, from what I understand, and they're all going to have to learn the SABs, and they're all going to have to get ready to deal with an influx of disputes under this new system. And they have some very tight timelines, according to Bill 15, that they're going to have to turn these around in. So it's, at this point, I guess the government has not yet figured out how to do this, because there's been no actual regulation introduced that has set a date when this changeover is going to happen. The last date that we heard was April the 1st of 2016. That will likely be pushed back, I would assume, to at least June 1st, so it coincides with the changes, but it might even be beyond that, so stay tuned. The big takeaways from this particular change is, one, your clients or your patients are going to lose the right to sue in court over accident benefits disputes, and that's a real problem for people who have both a tort and an accident benefits claim. For reasons I won't get into, it often makes sense to keep the accident benefits claim open until the tort settles, and we don't want to be litigating in two different venues at the same time. But that likely when this comes in, that's what we're going to have to do, because we don't have the alternative, as we do now, of suing and having the case work in parallel or lockstep with the tort claim. In terms of the process for the License and Appeals Tribunal, again, this comes from either what's in Bill 15, or there was a report of a retired Associate Chief Justice named Justice Cunningham that came out a couple of years ago, which sort of set up a framework for this new system. So be aware that whatever I'm telling you today could still change once they actually introduce the regulations, because it's not black letter law yet. But under the new system, there'll be no more fiscal mediations. There will be a denial, and then you have a chance to ask for an internal review of that denial, which they have 30 days to respond to. If you don't get that overturned, then you will have to contact the License Appeal Tribunal, and they will schedule a settlement hearing within 45 days. At that point, everyone's supposed to attend either by telephone or in person with a list of the evidence they're going to rely upon on this particular point, and they'll try to broker some sort of deal. And if that doesn't work, the next step is to proceed to some sort of arbitration at the License and Appeals Tribunal. And from what I understand, there's going to be 3 levels of arbitration. One will be a paper review for items that are less than $10,000. The second will be an expedited hearing, which would be for items that are more than $10,000 but fall short of things like catastrophic impairment or post 104-week income replacement benefit. And then the full in-person hearing will be reserved for those very significant cases that I just mentioned. So all of those are supposed to take place within a specified amount of time, which is also very short. So I'm at a loss to predict for you precisely how this is going to work in practice. But when these changes come in, again, it's going to be a matter of having experienced counsel and working together with them to try to dispute what you need to dispute, but also not end up with a whole bunch of litigation over minor matters that's not going to ultimately help the patient or your clients. So as of September 2010, they introduced this definition of incurred for attendant care, where basically a loved one who was providing attendant care had to show that they had incurred some sort of economic loss in connection with providing the care. Then there was litigation about whether or not you needed just $1 in economic loss to collect all of the Form 1 attendant care, or whether you needed an equal amount to whatever was on the Form 1. There was a case at the Court of Appeal which decided that it was just $1 or just some economic loss that you required in order to have a family member provide the attendant care and be paid for it. So the legislature changed the law as of February 1st, 2014, basically stating that it's dollar for dollar. So if the loved one loses $5, even if the Form 1 is $6,000, they will receive $5 for the attendant care that they provide. This is another case with prospective versus retrospective. Troy Lehman of my office has a case that's, there's a summary judgment motion which is under reserve at the moment about whether it applies to cases that existed before February 1st, 2014 or not. So as soon as that's out, I'm sure it will be widely circulated in the rehab community, but obviously anyone can contact me as well. I can't predict when it's going to come out, but we're hopeful that that will at least be a small victory so that if you have cases in the pipeline where the accident was before February 1st, 2014, it will be clear that all you need is $1 of economic loss. Anything to add, Darcy?
Just that because of the new math and the pots have kind of merged into a global pot, 1 + 1 is 1, so you can use it all for that rehab. You may be able to avoid the attendant care debate and rely on family members who just not even submitted to try to get insured and claim it in tort if you know you're going to use the $1 million for medical benefits.
That's true. So this is another issue with respect to tort. Again, it probably doesn't affect many people in this room, but just so you're aware, the prejudgment interest on pain and suffering and loss of enjoyment of life many years ago was tied to market rates for interest. And at that point, I understand that the interest rates were about 13%, and so there was a big blowback from insurers saying, why are we paying that kind of interest on non-economic damages? You know, people can wait 5 or 6 years to settle their case and then get 65% interest on their pain and suffering. So at that point, they changed the law to make it 5%, so that it was fixed. And it turned out that interest rates have gone the way that they have, and they're down to about 1%. So it's become a benefit to plaintiffs in the other direction that it's been 5% on general damages for the last number of years. So as of January 1, the legislature has changed that so that it is now the same prejudgment interest rate as it is for loss of income, which I believe is currently about 1%. And yet again, the legislature decided not to tell us whether it applies to new and old cases or only new cases. So there are 2 cases that have decided the issue to date at the trial level. They go in opposite directions, and one of the cases is going to the Court of Appeal sometime soon, and hopefully we'll get some final direction in terms of whether it applies to new and old or just new cases after Jan 1, 2015.
Yeah, and just the result of that is that in many of the smaller cases where the largely pain and suffering cases, it gives insurers incentive not to settle because they can do better than 1% holding money, and it's only accumulated to 1%, so they're often better off to delay settlement. So it's negative in that respect.
And they've also changed the accident benefits dispute interest rate. As you may recall, several years ago, we had this 2% compounded monthly punitive interest rate if the insurer refused to pay a benefit. And that could add up to millions of dollars sometimes on attendant care cases, for example, if there was years of dispute over the benefit. Well, that was subsequently changed to 1% per month, compounded monthly, and now they've changed it yet again as of Jan 1, 2015, so that once a dispute occurs between the insurer and the insured, it goes to 1% per annum, or whatever the market rate is at the time. It's only if you have a benefit that's not being paid and there's no dispute over it, it's just not being paid due to some issue with the insurer, that you continue to get the benefit of that 1% per month compounded monthly. So that's going to, again, negatively impact on plaintiffs or insured people because they're going to have a denial, and there's no incentive for the insurer to try to resolve it because they're not facing these punitive interest rates that they previously did. So the last topic, and I'm sure you're all feeling very sunny at the moment after all these changes, is the potential change to the MIG, the Minor Injury Guideline. Again, this hasn't been introduced into law, but there have been draft regulations that have been circulated, and I understand there's some sort of consultation process that's undergoing, that FSCO is holding with stakeholders at the moment. If you want more details about this, it's going to be called the CTI, or Common Traffic Impairment, assuming that it passes. You can speak to Darcy and I at the break, or you can email us. Our email addresses are on the paper. But it, again, sets out a type of MIG that is expanded so that all psychological injuries are included. Mild brain injuries where you have a Glasgow Coma scale of 13 would be included. So there's a number of more significant injuries that would not be covered by the current MIG that would fall into the CTI. There isn't in the draft regulations dollar amounts that are set out for how much each of these injuries, the pathway of treatment will include, but from what I understand, there will be dollar amounts. I'm sure it'll be more than the $3,500 that currently exists for MIG, but it may not be a lot more. And according to the CTI, by default, you are a CTI until you provide compelling evidence that you're not. So I think we're going to end up assuming that it passes, and I hope that it doesn't, in a lot of fights with the insurer trying to get people out of the CTI. And under the CTI, there's only 6 months of treatment, and you have these pathways that you go through, and if you're not better, from what I understand, you're out of luck unless you can convince them that you're not a CTI. So more fun to deal with, and we're going to have to see how that progresses down the road, but hopefully calmer heads will prevail in terms of the CTI, and if there are changes made, they won't be as draconian as some of the things that I've read in the draft regulations.
Yeah, and just to add to that, right now, once in a while, we get a case where the original teams involved submit the OCF or the disability certificate suggesting a whiplash type of injury. The cases get stuck in the minor injury guideline because the person fills it out as treating just that condition. And they don't mention the brain injury or anything else. And the person gets stuck in the minor injury guideline, and it is a disaster to try to get them out. So the classification problem will be heightened by this new provision which covers mild brain injury, and we need the teams to be more aware of that and to make sure that from the get-go the forms are complete, comprehensive, and try to reference items that may be outside of the CTI.
Well, that's the summary of all the changes. I'm sure it's a great start to the day, but as I mentioned, you know, it's something where we've been through this before. Over time, creative lawyers and good treatment people and hospital-based treatment people who are in this room find ways to work around these things. There's a concept that I'm familiar with called threshold erosion, that whatever you set the threshold at over time, over 5 or 10 years, ultimately it gets watered down through the courts and through decision makers like potentially the LAT. So I want everyone to be aware that we're all going to be working very hard to try to find creative ways to work within this new system. And then, of course, firms like the PIA firms are going to be trying to do things where there's a tort claim to fund reports and assessments that will be beneficial for both tort and accident benefits as medical legal expenses, as opposed to putting them through this accident benefit system in order to try to preserve the money that's there for the people who really need it. So I look forward to working with all of you in the new world, and we'll get through this together.